Welcome to the University of New Hampshire School of Law podcast, where every week our professors give legal insight on important news topics. Learn more about the law school by visiting law.unh.edu. Today we are with Professor John Greabe to discuss Defense Distributed's case revolving around plans for 3D printed guns. Please note, opinions discussed are solely the opinion of the faculty or host and do not constitute legal advice or necessarily represent the official views of the University of New Hampshire. So let's just start off with, what are the basics of this case that was recently put through the federal courts?
It's been an ongoing dispute. Initially, it was a dispute with the federal government. The State Department sought to keep this company, which is centered in Austin, Texas, from distributing plans or making available for public download plans for printing on a 3D printer firearms. In June, a settlement was reached between this company and the State Department, and it was agreed that they would be able to make these plans available. Subsequently, as that was about to start to happen, and actually even after, my understanding is that there were over 1,000 downloads before this new lawsuit was filed. This was filed by a bunch of states. 8 states initially filed suit in the state of Washington and obtained a temporary restraining order, which is a very, very short-term order preserving the status quo. I think a couple days later, 11 additional states joined in. So it's about 19 or 20 states that are now actively involved in this. And there's supposed to be a hearing tomorrow. But basically, they are arguing that it would be dangerous for these plans to be made widely available. These 3D guns can be printed in such a way, as I understand it, that they don't have any metal and would not be detected by a metal detector. They are also going to be printed without serial numbers and therefore would not be traceable and otherwise subject to the regulation that that traditional firearms are.
Like, this originally came out in 2015, I believe it was, where the Liberator was the name of the gun. Same guy, Cody Wilson. But now he doesn't even just have the Liberator, which I believe is still in this. He's got a whole slew of guns that you could build off of just a basic base that basically anyone can get now without a license.
That's what I understand too, including something modeled on the AR-15,
which to me just seems like he's just intentionally pushing things, because this is, for the most part, he's outright said, is a activist company. I mean, the whole point of it is to basically create what's happened right now. What's interesting about this from a constitutional perspective is it comes across as a Second Amendment case, but it's very much a First Amendment case.
Yeah, this is a case where, there's an intersection, I suppose, between the First and Second Amendment. Let's start with the Second Amendment part of that. There is, for the last decade now, the Supreme Court has recognized that there's an individual Second Amendment right to own firearms, that right keeps both the federal government and the states from too heavily regulating one's ownership. Now, that said, I don't actually think that there's a very, very strong Second Amendment component to this case, because in the 2 cases that the Supreme Court has issued about the Second Amendment, they've been very clear that regulations of gun ownership are going to be permitted, reasonable regulations. I mean, what those cases basically established was the right to own a firearm and to possess a firearm in one's home for purposes of self-defense. It's a pretty big jump from that right to a right to download and print a firearm that, again, doesn't have a serial number and is not detectable by metal detectors.
And each state has entirely different laws about how they handle guns, too.
Yeah, I mean, I would be very surprised, at least in the short term, if any court recognized that there were a constitutional right held by all citizens, regardless of their criminal background, et cetera, to download and print these guns. So I don't. Yes, the Second Amendment is sort of involved, but it's kind of, I think, on the periphery of the case. This case in particular is about the First Amendment because the claim is that there is a First Amendment right to disseminate information. And yes, this is code, computer code. It's not traditional speech, but the weight of the authority on the issue suggests that the distribution of code is expressive conduct that is treated as speech and therefore protected by the First Amendment. And so really the issue is a threshold issue in this case. is making this code available for download. Is that an expressive act protected by the First Amendment? The First Amendment is notoriously inconsistent. There are precedents that one could invoke in support of the argument that this is conduct, it's not speech, and conduct can be regulated in ways that speech cannot. And yet, on the other side, there's also precedent suggesting that this should be treated as, if conduct, expressive conduct, that is treated as speech. And I think that the weight of the authority is probably in favor of that other view, the view that this is speech. And so that's a threshold issue in the case. Is this is what this guy wants to do? Is it something that's protected by the First Amendment? I think the argument is pretty strong that it would be. And once you say that it is protected by the First Amendment, the legal test that kicks in makes it very, very difficult to stop the communication of information. You have to have a compelling government interest to do so, and even if you have a compelling interest, and I think you can make an argument that public safety, right, is a compelling interest, you have to do it in the most narrowly tailored way possible. And that's where I think the states are going to run into difficulty, because the argument is, look, you don't have to stop the speech. You can just make it illegal to possess these firearms, for example. You could make it illegal to take them out of your house. I mean, there's all sorts of ways you can do it short of stopping the communication of information. And it's just deeply embedded in our culture that it is anathema for a court to issue an order saying that information cannot be transmitted from person A to person B or even to the general public.
I mean, this just off the top of my head right now made me think of like the Anarchist Cookbook. I mean, it's a similar kind of thing, only now it's digital.
That's right. And on top of that, we also have this strong tradition of not allowing what we call prior restraints of speech, which are, speech licenses or orders from courts telling somebody that they cannot communicate. That's at the very heart of the First Amendment. And so, an order from a court saying that this information cannot be made available, can be characterized as a prior restraint of speech, which is presumptively unconstitutional under the First Amendment. And the fact that, as you just said, that there are all sorts of other communications, sources of information out there that can be misused by people to commit crimes. It makes it, I think, an uphill argument for the states in terms of arguing that that the only way to deal with this is to put a gag order effectively on this individual.
Once it's out, it's out. I mean, the first rule of the internet: once something's there, it's there forever.
That's right, too.
They have more than 1,000 downloads, and once it's there, it's not DRM protected. Anyone can use it.
That is another problem. Yeah, I mean, once it's out, what do you do? You're gonna issue orders. You're gonna find everybody who has downloaded it, and then try to bring them within jurisdiction of the court. I think it's an uphill battle.
As news develops on this story, we will definitely follow up on your podcast feed. Thanks to Professor John Greabe for joining me today. He is also the director of the Warren B. Rudman Center for Justice, Leadership, and Public Policy. Learn more about the center at law.unh.edu/Rudman. And follow him also on Twitter at John_Greabe. Thank you for listening to the show. Get the back episodes at law.unh.edu/podcast, which also has links to subscribe to the show on all your favorite podcast services, including Apple Podcasts, Google Play, and now Spotify. Be sure to like and comment. It really helps spread word about the show. Talk to you next Thursday. Opinions discussed are solely the opinion of the faculty or host and do not constitute legal advice or necessarily represent the official views of the University of New Hampshire.